federal government is being affected, a federal election, a presidential election, the entire campaign law process at the federal level is now affected by this one court in this one state. And you got to put that back in the box. And there's only one institution that has the power to do that, and that is the United States Supreme Court. So which is the court? That if you can get it to the court, if you can find a procedural pathway to the court, which is the court, and the only court that has national authority over a presidential election if the Constitution is violated? It's the United States Supreme Court. So you look at that, you say, okay, has the Supreme Court ever intervened in a federal election when it thought the Constitution was violated? Yes. It's called Bush versus Gore, almost 24 years ago. Okay, then you read that decision. What did they say? There were split decisions, but 7 of them did vote on the application of what? The Equal Protection Clause. So what is the pathway here? My argument. You have a violation of due process under the 5th and 14th Amendments. You've been watching Fox or listening to me for 6 weeks now, and there's so many examples of due process violation, they're almost impossible to compile. They feel like they're infinite. And that's the point. What was the point of all these due process violations? To influence the election. How? How? To get a guilty verdict. To get a guilty verdict. And so, while you're in the one lane trying to overturn that guilty verdict, you're in this other path you're trying to create to the steps of the Supreme Court and figure out what arguments can you make that might persuade them, even if you have a 10% chance. Okay, well, we have Bush versus Gore. So we want to basically stay as close to that as we possibly can, even though there are some differences. But the similarities are what you emphasize. First of all, you have a situation where you have a prosecutor and a judge that is a state court seizing federal jurisdictional authority in a federal campaign, and not just any federal campaign, the most important federal campaign that the nation holds. That is the campaign for President of the United States. That's number one. Number two, you have a myriad of 5th and 14th Amendment due process violations against the putative Republican nominee, the former president, who will be the Republican nominee, thereby effecting the ability of the Republican Party, members of the Republican Party, donors, and the candidate himself to participate as equal participants in a presidential election. But the due process also flows to you and me. When they are unable to participate in a normal and routine manner in a presidential campaign, that affects you and me, Mr. and Mrs. America, the citizen, the voter. We don't have access to the candidate. 5-6 days out of the week, we can't hear from the candidate. Maybe we want to go to a rally to meet the candidate. Maybe after we meet the candidate, that'll make our decision to support the candidate. There's, you get 1,000 possibilities when you're running a campaign. The fact is that the campaign is handicapped. I don't care when people say, but his poll numbers go up. It's irrelevant. That's a snapshot. We don't know what the end result's going to be, but we do know what the result is now, that one campaign can campaign unfettered and another campaign is shackled, or at least was, for 6 weeks. For 6 weeks. And that judge is not done, depending on what the appellate courts do in New York. Maybe he won't stay a sentencing. Maybe he'll issue a sentencing that's problematic. The problem throughout this is they've created a scarlet letter which that candidate now has and carries into the entirety of the election, and which his opponent is going to use. Convicted felon, Donald Trump. Convicted felon, presidential nominee. Convicted felon. They're bragging about this. They're giddy about this. The media, same. So obviously, I will put it my way. This doesn't help Donald Trump. Well, we got in more money. No. But in the long run, you don't know the impact. And the impact is, if Donald Trump had a choice, would he have gone through this or not? Of course not. Has he explained that this is corrupt, it's campaign interference? Yes. He wouldn't say those things if he thought it was going to help him, would he? So all the static aside, you're the advocate. You're trying to get to the Supreme Court. So you have this due process issue. You have the interference in a presidential election. Okay, we've got some patina, or actually more than a patina, of the Bush versus Gore precedent from 2000. And you have equal protection arguments that you can make as well. What are they? The ones I just said. One campaign versus another. One campaign unfettered, another campaign shackled. Okay, great. Now, how do you get to the Supreme Court? Well, you can follow the New York rules, and you can follow the statutory process, even at the federal level. New York rules is you have to finish all your appeals. Well, that won't work. That won't work because, what did I say? The purpose of this entire thing was to interfere with and affect the outcome of an election by a single prosecutor and a single acting state judge in a blue state who both are all conflicted up. That's number one. Number two, what about all the other prosecutors in all the other states? Is it now freebie time to take your shots at a presidential candidate, particularly in a heavily partisan jurisdiction? How do you get this to the court? Well, you can't wait for the appellate process then in New York. Well, you have a writ of certiorari. That is, you can ask the court, okay, court, look, we've gone through the New York process and so forth. You're the court of last resort. Look at all these violations. The New York court didn't rule the way we wanted to, or its ruling actually was okay in terms of our client, but still whether you can do that, wait till after the election, which defeats the purpose. But you still want to preserve those appeals. Why? Because you're building a path to the Supreme Court that the Supreme Court may not entertain. You still have deadlines on the appellate process in the state. You don't want to blow through those. So you still need to do that for your client. And ultimately, if the best thing you can do has to be done after the election, then it's done after the election. But you don't have to just stand for that. So you try and build a path to the steps of the Supreme Court. Well, this writ of certiorari won't work. Why? Well, the state court's not done. And I can find no federal statute that provides for a path to the Supreme Court, a runaround, an end around. But there is a way. And I've spent time digging into this, and I've sought the advice of one or two people who I trust. And let me tell you and read to you what I posted on social media last evening. The issue is now to get out of the New York system and bring the case to the Supreme Court, which may or may not take it up. That's second lane. This is why I looked to Bush versus Gore, where the Supreme Court decided to step in because it was a presidential election. And I would argue, if I were arguing this to the court, this is even more critical. Because in the Florida case, the Florida Supreme Court wasn't claiming federal jurisdictional authority over federal campaign law in a federal presidential election. It didn't even come close to that. It was mucking around within the state. What this court did is it reached into the federal government and said, you know what? We're going to take that. We don't even know what that is, but that's a secondary point. We're going to take that and use it to revive our state statutes to affect a presidential election, right? It's even worse in my view. So I look at Bush versus Gore, where the Supreme Court decided to step in because it was a presidential election. There was another court involved, as I explained, the Florida Supreme Court and so forth. In New York, you would file the notice of appeal to preserve your right to appeal and ask for a stay of the trial court. Stay the sentencing while you are considering the case. And I would file an emergency notice of appeal. I'm not familiar with the New York procedures, but New York lawyers know how to do this. It's not brain surgery. They open a book and they read it. And I would seek from that New York appellate court an expedited or emergency review. Then I might file applications for the common law writ with the U.S. Supreme Court, where the Supreme Court can take action if it chooses and legitimately claim the harm is immediate and ongoing, I would argue, but that the federal electoral system, the federal campaign jurisdiction issue, reverse federalism, as I discussed, and the precedent that it might create through the back door if left unchecked. There's already a bad precedent. What is it? That people are sitting around waiting for one state to decide the fate of a presidential candidate. That's already bad precedent. The fact that we're in this court going up one state's chain of appellate process, that appellate process, if it's not challenged, is binding on a federal presidential candidate, and that state appellate process involves federal law, the whole thing is screwed up, and we have to wait for that to finish. The fact that it's taking place is fact enough to seek a Supreme Court intervention. So I told you a writ of certiorari won't work. That's the way 99.9% of cases are brought to the Supreme Court. So what do? It's something called a common law writ. A common law writ. What is that? It's a judicially created, if you will, writ. It goes back many centuries. It goes back into British law and so forth, or British common law. A judge looks at or justices look at what's presented. They say, okay, it's not a writ of certiorari, we know that. We know what a common law writ is. We've seen these all the time and reject them all the time with rare exceptions. But this is now giving us an opportunity to take up this case as the Supreme Court. As the Supreme Court. I would argue, not just as an appellate court, but as the Supreme Court, to examine this for a multitude of reasons, and you provide those reasons to the court. The reasons include everything I've said and everything everybody else has said for the last 6 weeks. But you tie it to the federalization of what took place in the Manhattan court, that is the reverse federalism, where now the federal government is being affected, a federal election, a presidential election, the entire campaign law process at the federal level is now affected by this one court in this one state. And you got to put that back in the box. And there's only one institution that has the power to do that. And that is the United States Supreme Court. And we're only here because the Democrat Party is so loathsome, conducting itself in such outrageous ways that it is now, in its fundamental transformation of America, it has now devoured our legal system. So our legal system is not really a justice system anymore. It's a legal system. There are lots of corrupt legal systems all over the world. It's a legal system. We have a justice system, and they're not the same thing. The justice system is being destroyed by the destruction of the legal system. I can't think personally of a more compelling reason for the Supreme Court to accept a writ at common law than this case. It triggers every, or virtually every issue that will continue to make its way to the Supreme Court if this isn't resolved now. What are you talking about, Mark? The door is open. Tyranny is here right now. Is every blue state hack prosecutor, whether it's Fani Willis, Alvin Bragg, you've got them all over the country, now free to do what was done? That is kangaroo, star chamber, third world-like courts? And the people all over the country are going to be bound by what takes place in that court? I don't live in New York. I don't live in Manhattan. I'm right now here in Virginia. If I'm not in Virginia, I'm in Florida. I have nothing in common with the politics of New York. That prosecutor wasn't elected by me. That judge isn't my judge. That judge has authority over Manhattan, New York law. Not me in Virginia. Not you in other states. Not over the federal system. If the Supreme Court is going to step in, now would be the time.
For more, sign up for LEVIN TV.